Okay, agreeing to. Sorry, I got distracted because of the recording. But I think the market has potential considering the various Chinese investments in Nepal. As all of you may be aware that China recently, Nepal took a loan from China to build our Pokhara International Airport, and Nepal has already been defaulting in the loans. Very recently, in April 2024, Nepal also signed a deal with China to build a railway network from Lhasa to Kathmandu, and that project is like apparently an $8 billion project, with Nepal already investing 24.8 million in the feasibility study, and Nepal is going to spend at least like 5 billion in the project alone. So you could keep a lookout for these kind of disputes with China. So it's definitely, in the future, it will definitely be very, very interesting to see how the arbitration landscape will develop, and therefore it's very important that you guys are educated in arbitration, and we subsequently amend our arbitration laws. So therefore, it's my pleasure to introduce to you my former colleague, Mr. Gary Bourne, to do this very special lecture. When Gary agreed to do this lecture for us, we actually ended up making this like a nationwide event rather than just limited to Kathmandu University. So it's actually students from all around Nepal joining us today. And I have been told that there are some people from Afghanistan and Iraq as well who registered to join the event. So, I mean, it's kind of like really special to know that so many people know Gary. And Gary is not only a very, very sharp lawyer, but also a very, very good storyteller. And I can vouch for his storytelling abilities, because I and my mom have been a huge fan of his action thriller, The File. And if you get a chance, I definitely recommend that you read the book. It's really gripping. I couldn't keep it down the moment I started reading it. I wouldn't tell you what the story is, but it's like a very, very good balance of suspense, action, and romance all at the same time. So even if action thriller is not your genre, then might as well read the book. So yeah, I give the floor to Gary. Gary, please, start your very, very special session. Thank you, everybody.
Thank you so much, Arya, and apologies for the commercial break. I would note as well that Arya chose to talk about my thriller, not about my arbitration books, which might be a little bit more relevant for today's purposes, but which I can guarantee you aren't nearly as interesting or gripping. Our topic today, as Arya indicated, is. So my video is not on? I'm seeing a message from...
No, Professor, that's not for you. And that's for
okay.
the participants.
Okay. Good. I was worried. So our topic today is an introduction to international commercial arbitration. And if I'm correct, Arya will be speaking about an hour. Is that correct, or is it a different time? We have a slide presentation, and perhaps in the slide presentation, if we can go to the very beginning of it, and after this session is finished, Arya can distribute the slides so that everybody will have them. They are much too long for the hour or so that we have together today, but they will give you background information. If we could go to the next slide, what I would like to try and cover today is just very quickly the definition of international commercial arbitration, number one, the reasons for using international arbitration, especially international commercial arbitration, number two, and then skipping ahead finally to the legal framework and sources of law for international commercial arbitration. And we're going to take those three topics quite quickly. As you can see, the slide deck has a number of other related topics in it, and you're more than welcome to browse through that in your own time. Let's start, though, on the next slide, just very quickly with a definition of what this course is about. What is the subject that we'll be discussing together during the next weeks? It is international commercial arbitration, and each one of those words actually is important in defining what we're going to do. Most fundamentally, the topic that we will be discussing is arbitration. Arbitration is a particular means of dispute resolution. Its purpose is to resolve disputes, to put an end to disagreements. Its purpose is not to do other things. Its purpose is not to create contractual relationships. It's not to mediate or conciliate a dispute. It is rather to resolve, and to resolve finally particular disputes which have arisen. Arbitration can be used in a number of different contexts, both domestic within the borders of a single country, but also international between parties in different countries, or in some circumstances between different nations themselves. Arbitration can also cover a number of different subject matters. We will be focusing on commercial arbitration, but there are other types of international arbitration. There is state-to-state arbitration, which, as I suggested just a moment ago, involves resolving disputes between countries. And there's investment arbitration, which is closely related to commercial arbitration. Let's spend a moment, though, if we can move to the next slide, and discuss in greater detail what arbitration is. One sees almost as many definitions. In fact, I sometimes think more definitions than there are authors or authorities in the field. Almost every commentary writer, almost every court has an opinion, sometimes 2 or 3 different opinions on what arbitration is. You can see a characteristic example of what arbitration is on the current slide. It's from a decision of the Swiss Federal Tribunal, and it says, consistent with the traditional notion of private arbitration, one may define an arbitration agreement, an arbitration clause, as an agreement, and now this is the important part, according to which 2 or more determinable parties agree in a binding way to submit one or more or several existing or future disputes to an arbitral tribunal, to the exclusion of the original competence of state courts and subject to a directly or indirectly determinable legal system. If we can go to the next slide, please. There are a number of important characteristics in that definition, which you can also see, and I won't take you through each one of these definitions because they're rather similar. There are a number of common elements in most definitions of arbitration. If we could go to the next slide, and I think probably go pretty quickly through it. The basic definition of arbitration includes the elements that you can see now on this slide. And also, we don't need to go back to it, but also on the preceding slide, which was my own personal favorite of definitions. Arbitration, but let's stay on the slide with the laundry list. Arbitration, firstly, is consensual or contractual. Arbitration arises by virtue of the parties' agreement to do something, and in particular, to arbitrate. Unless you have an agreement, a contract between the parties to resolve their disputes by arbitration, you don't have arbitration. The second key element of the definition of arbitration is that it involves a non-governmental decision maker. And by that, I mean a decision maker other than a national court or administrative tribunal or regulatory authority. An arbitrator is a person like me, like you, like Ms. Dixit, who's chosen by the parties, a non-governmental person, who's chosen by the parties to resolve their dispute in a final and binding manner. And that involves this third of the elements that you can see on the current slide. An arbitrator is an individual who's chosen either by the parties, that very frequently happens, the two parties will agree, we would like Professor Bourne to resolve our dispute as arbitrator, or alternatively, if the parties can't agree, then a third party, either an arbitral institution or a national court, will choose the arbitrator for them. Critically important, though, is in the definition of arbitration, a non-governmental decision maker is chosen either by the parties themselves, most frequently, or sometimes on behalf of the parties because they are unable to reach agreement themselves. And the arbitrator is chosen to resolve their particular dispute. He's not, or she's not, a permanent arbitrator. He or she doesn't stand waiting for disputes to arise. Rather, he or she is chosen by the parties for a particular dispute. And critically, the arbitrator is chosen, because this is what arbitration entails, to make a final and binding decision. The arbitrator is not chosen to mediate or conciliate between the parties, to encourage them to reach a settlement without the authority to impose a decision on them. Critical to the concept of arbitration, and it's related to the next item on our list of bullet points, is the final resolution of a dispute. The arbitrator may reach a decision, which is called an award. We'll learn more about these things, awards, in the course of the next weeks. Critical to the definition of arbitration is that the arbitrator makes a decision, an award, that resolves the parties' dispute, whether or not they like the way that she resolves the dispute. Both parties may think that the arbitrator got things badly wrong, but nonetheless, that award isn't a suggestion, it's not a recommendation, it's not a proposal. It is a final and binding decision subject to only very limited judicial review, whose purpose is to finally resolve the parties' dispute. And then finally, the last item on our list is the use of what are called adjudicatory procedures. The arbitrator is required to hear the parties, to give them an opportunity to present their cases, and only after having heard the parties will the arbitrator make that thing, that award, which resolves their dispute. That contrasts with some means of dispute resolution, which are a bit like arbitration, so-called expert determinations, where an expert chosen by the parties contractually to resolve their dispute does so without hearing the parties, only using her or his expertise as the basis for the decision. Arbitration is different. Arbitration involves hearing the parties' submissions on facts, on law, on other things, and making a decision based upon those submissions and not on other things. Taken together, all of these 6 elements define what arbitration is. It's a consensual means of finally resolving disputes by means of a non-governmental decision maker chosen by or for the parties to issue a final decision after hearing the parties' cases using adjudicatory procedures. If you fit within that definition, you're something called arbitration. If you fall outside that definition, you're not something called arbitration. And the reason that that's important is not just because law professors like to make up little definitions, but because the entire legal framework that we're going to discuss in a few moments is based upon arbitration. It applies to things called arbitration, things called arbitration agreements, things called arbitration awards, and it doesn't apply to other things. Just very briefly before we go on and look at in more detail what that legal framework is, let me distinguish arbitration from a couple other categories of dispute resolution, which look a bit like it and which it's helpful to discuss how it's actually different. I mentioned one of these already. It's conciliation or mediation. In conciliation or mediation, the parties consensually choose, by way of a contract, to mediate or to conciliate their dispute. They choose voluntarily a non-governmental conciliator or mediator whose purpose, after hearing the parties, is to try and resolve the parties' dispute. That sounds a lot like arbitration. It's consensual, non-governmental decision maker, use of adjudicatory procedures, and it's aimed at resolving a dispute. It's fundamentally different, however, because a mediator or a conciliator can only recommend or propose how the parties voluntarily can enter into a new agreement to settle or to resolve their disputes. If they don't enter into that new agreement, if they don't like the mediator's proposal or recommendation, they have no obligation to accept that proposal or recommendation. They have complete control over whether or not they will agree to waive or to compromise their claims. And that's fundamentally different from arbitration, notwithstanding those similarities we talked about a moment ago. It's fundamentally different because, as we saw, arbitration involves a final arbitral award, which, whether one party or both parties don't like that award, is nonetheless binding upon them and can, importantly, be enforced in national courts over their objections. And in that sense, although there are similarities between mediation and conciliation on the one hand and arbitration on the other hand, there is a fundamental difference in the two. There's also a difference, which I mentioned very briefly previously, between arbitration on the one hand and expert determination. You often see in commercial contracts a so-called expert determination provision. The parties will provide that if some typically financial or accounting matter or some highly technical matter, calculation of oil reserves in an offshore oil block or calculation of annual depreciation in a financial formula in a loan agreement or something of the sort. If there are disputes about those financial or technical calculations, they will be resolved by somebody called an expert. The parties agree to be bound by what the expert decides with respect to those matters that I described, calculation of oil reserves or calculation of annual depreciation. And in that sense, an expert determination is very much like an arbitration. It's consensual. The parties agree to resolve certain disputes by expert determination. It's a non-governmental decision maker. The expert's not a national court. He's chosen or she's chosen by the parties, or in some cases for the parties by an institution. He or she is assigned to make a final and binding decision which resolves the party's dispute. And in that sense, expert determination really is a lot like arbitration. How's it different? It's different, as I mentioned a few moments ago, simply with respect to the last element. It does not use adjudicatory procedures. It doesn't require the expert to hear the parties, to hear their evidence, to hear their legal arguments, to hear them in person at a hearing, an arbitration hearing. He rather or she can go off by themselves with some documents provided by the parties and explore what, based on their expertise, they think the right answer is, and their decision, what they say the right answer is, will be final and binding. But it's not arbitration. And an expert determination agreement isn't an arbitration agreement, and the final expert determination isn't an arbitral award. And the reason that's important, as we'll see, is the entire legal framework that we're going to discuss for international commercial arbitration doesn't apply to these things called expert determinations. And then just very quickly, before we move on, arbitration is also different from so-called forum selection or choice of court clauses. One sometimes sees in commercial contracts provisions that, in the event disputes should arise, all those disputes will be resolved in a specified national court. English courts, for example, or courts in Geneva, Switzerland, or courts in Kathmandu, Nepal. That is a so-called choice of court or forum selection clause. It's similar in many ways to an arbitration agreement. It's consensual. It chooses the place, the institution that will finally resolve the parties' disputes, and typically it will do so using adjudicatory procedures. And in that sense, those forum selection clauses look a lot like arbitration, which you can see the elements of again on the current slide. It's fundamentally different, however, because an arbitrator is a non-governmental decision maker who individually is chosen by the parties. A national court, whether in Kathmandu or London or somewhere else, isn't a non-governmental decision maker. It's a governmental decision maker. And the individual judge isn't chosen by the parties. Rather, it's assigned by the judicial institution to which the parties have submitted themselves. And critically, forum selection clauses aren't arbitration agreements, and national court judgments are not arbitration awards, and they therefore do not benefit from the legal framework for international commercial arbitration, which is what we're going to discuss next. And Ari, if we could move through the next slides very quickly until we get to reasons for arbitration. The students will be able to go through these slides, and if we could just keep scrolling through them. The students can go through these slides, and what they basically do is provide some more detail to back up all of the things that I have said over the last 15 minutes or so. Let's keep going. These various slides, which you can see, address. Okay, let's back up just a little bit. Great. A little bit more. Bit more. Bit more. Okay. So, and those slides that we just went through, which you're free to look at in your spare time, will give you more explanation, more detail about each of the elements of arbitration, which I discussed. I promised you earlier that what we were discussing was international commercial arbitration. And that is a broad definition. It relates to the resolution of any sort of business dispute between companies or state-owned companies, state entities, as long as it is engaged in commercial matters, typically matters that involve trying to make a profit. Most of the international treaties and national arbitration statutes that we're going to study over the next weeks are focused specifically on this topic, international commercial arbitration. They don't apply, for the most part, to state arbitration, and they only apply occasionally to investment arbitration. They're focused very much on business disputes. Next slide, please. And we can see that, and I'll take this extremely quickly, in both the so-called New York Convention, and I'm going to say a lot more about that in just a couple minutes, which, as you can see on the slide in Article 1.3, is focused on commercial matters. And if we go to the next slide as well, most national arbitration statutes, and a good example is the UNCITRAL model law on international commercial arbitration. I promise to tell you a little bit more about that as well in a few moments, is focused on commercial matters. And you can see that in the very first provision of the model law, Article 1.1, which is in the bullet point at the top of the slide. This law applies to international commercial arbitration, and commercial, both under the UNCITRAL model law and national arbitration legislation in other jurisdictions, is defined very broadly. Next slide, please. And for an example of how broadly it's defined, you can see this footnote to the model law's reference to international commercial arbitration. We'll have an opportunity to come back to this in future classes, but for present purposes, it's enough just to note that this is what international commercial arbitration is: business disputes, extremely broadly defined. Next slide, please. And let's keep moving through the slides until we get to international, which is right now. And we're going to focus specifically on a particular kind of commercial arbitration, and that is international commercial arbitration, which involves arbitration agreements and arbitral awards, either between parties from different countries or involving contracts that include performance in different countries. The New York Convention, and we're going to get to that in just a couple of minutes. The New York Convention is directed specifically at so-called foreign arbitral awards, arbitration awards that are made in a country other than the place where one tries to recognize them. And the UNCITRAL model law, if we can move to the next slide, is focused specifically on international arbitration. You can see that from its title, the UNCITRAL model law on international commercial arbitration, and you can see it in the definition of the model law there in Article 1.3. So you can have commercial arbitrations that are purely domestic, that involve two Nepalese that are engaged in a commercial transaction that has nothing to do with any other part of the world, purely Nepalese, just confined to things that are happening in Pokhara or Kathmandu, but not anything with any neighboring country or any other country in the world. Those domestic commercial arbitrations can sometimes look a lot like an international commercial arbitration, but importantly, they won't be subject to the international legal framework that we're going to be looking at during the next weeks during this course. And in particular, they won't be subject to the New York Convention. We're going to talk about that, as I promised, the UNCITRAL model law, and similar national arbitration statutes dealing with international commercial arbitration. And so with that background about what the topic is, international commercial arbitration, let's turn very quickly, if you can find the bit of the slides that have to do with the reasons for international arbitration, we can just spend a moment right here about why it is we even have this topic. Why is there a course on international arbitration? Why is it that parties, commercial parties in particular, want to use international arbitration? And as you can see on the slide, international arbitration, this consensual means of finally resolving disputes by decision makers chosen by or for the parties, is preferred overwhelmingly by commercial parties because of what I like to call the 5 or 6 E's. And they're referred to not exactly as the 5 or 6 E's on the current slide, but it is because business parties all over the world have concluded that international arbitration is, number 1, more expert, number 2, more expeditious, number 3, more efficient, number 4, more even-handed, number 5, more enforceable, and number 6, more electronic than the alternatives. Before we talk about the 6 E's, what are the alternatives? The alternatives for resolving cross-border disputes, international commercial disputes, of course, is national courts, state courts, either in, as I mentioned, London, Nepal, China, somewhere else. Most businesses, particularly in international commercial disputes, do not like submitting their disputes to national courts for resolution. They don't like doing that because they're concerned that national courts won't have the appropriate expertise, won't be sufficiently expeditious and efficient, won't be even-handed. Both parties very frequently are concerned about being subject to the courts of their counterparties' jurisdiction. To pick up Aryu's example, do the Nepalese borrowers want to be in Chinese courts for disputes about their indebtedness or about the railroads or roads that might come to be constructed? Absolutely not. And most commercial parties don't believe that national court judgments will be as enforceable as arbitral awards. Let me say a few words now about each one of the 6 E's. Arbitration is regarded by commercial parties as more expert than the alternatives, and in particular national courts, precisely because parties choose the arbitrators, and in particular after a dispute has arisen. What that means is that instead of going to a national court where the judge, who often has no business experience at all, has to nonetheless decide a caseload that involves insurance cases, administrative law cases, criminal cases, contract cases, telecommunications cases, landlord-tenant cases, employment cases, every kind of case under the sun, which necessarily means that those judges will not have particular expertise in a specific subject matter, particularly not an international commercial subject matter. In contrast, when the parties have, for example, a road construction dispute governed by say, English law or the law of Kuwait. After the dispute has arisen, the parties can choose the arbitrators specifically for their expertise in road construction disputes in, if this is the applicable law, English law or Kuwaiti law or some other law. It allows the parties to handpick a tribunal that has the best possible attributes to resolve their particular disputes with the most available expertise that one can find. Necessarily, that is going to be superior to what one finds in a randomly selected judge from a national court. In part, for that very reason, arbitration is both more expeditious and more efficient. It's more expeditious because you don't need to educate the judge on, for example, the complexities of an insurance or a reinsurance policy or a road construction contract or a telecommunications joint venture. All that education takes time and also money. And if you've chosen arbitrators who are expert, you don't need to go through that re-education process. Also, extremely importantly, arbitration typically does not involve appeals. Arbitration involves a single adjudicatory process that results in an award, which itself is final and binding. Almost all national courts involve 2, 3, maybe more levels of appeal, which necessarily takes significant amounts of time and also costs significant amounts of money. In contrast, arbitration with an expert tribunal chosen for a particular dispute allows that tribunal to act very expeditiously, and therefore, because lawyers are a little bit like taxi cabs, they charge by the hour. The more time they take, the more expensive they are. The arbitration process has the potential to be more efficient. And also importantly, most arbitral institutions, as we'll see, particularly in smaller value disputes, have created so-called fast-track arbitration procedures, which, if the dispute is only of a value of less than $1 million, a couple $1 million, the arbitral institution can put the arbitration on a fast track, which means that the arbitral award will be rendered in a month, in 6 months or less. And arbitral institutions, arbitral tribunals are quite good in keeping to those particular time limits. And as a consequence, the first 3 E's, expertise, expeditiousness, and efficiency, all weigh in the minds of commercial parties very significantly in favor of arbitration. Arbitration is also, international arbitration is more even-handed. If you have a dispute between, say, a Nepalese and an Indian party, the Indian party probably doesn't want to be in Nepalese courts, and the Nepalese party doesn't probably want to be in Indian courts. Both parties, probably with good reason, mistrust their counterparties' home turf. And as a consequence, they would prefer a neutral third forum, somewhere other than their counterparties' home courts. And that's what international arbitration offers. The parties can seat their arbitration, provide for the arbitration to occur in a neutral third country. They can agree to resolve their disputes in, say, Singapore or London or somewhere else that is neutral as between the two parties. And thus, the arbitral process is more even-handed. That is underscored by the fact that arbitral tribunals are required to be independent and impartial, underscoring the even-handedness of the arbitral process as compared to the alternatives. Last, or almost last, number 5, arbitration is more enforceable precisely because of that legal framework, which I promised to get to. And if I hurry, I think I'll manage the New York Convention and national arbitration legislation, which gives very powerful effect to both arbitration agreements, making them presumptively valid and enforceable, and the same thing with arbitral awards, making them presumptively valid and enforceable, subject to only very narrow exceptions. In contrast, there's no international treaty, no meaningful international treaty that deals with choice of court agreements or national court judgments. There's no New York Convention for national court judgments. And finally, in this post-COVID age, international arbitration is, as this Zoom seminar illustrates, more electronic. International arbitration didn't stop during COVID, as many national court processes did. Rather, it moved online. Very frequently today, major parts of the arbitral process are conducted by Zoom, by Teams, by some other online platform. And that underscores again the second and third E that we discussed a moment ago. It makes the arbitral process more efficient and more expeditious. One doesn't need to fly people halfway around the world or all the way around the world. One can simply have a procedural conference, have an application for interim relief, even a final hearing online. And those, therefore, are the reasons that commercial parties prefer arbitration to the alternatives. And now just very quickly, if we can go to the legal framework, and I know, Arya, what time should I be aiming to wrap up? And do you think I should leave some time for questions?
So aim to wrap up around what time is it? It's like 2:53 in London, so around 4:15.
Oh, 4:15. Okay, we've got lots of time then. Okay, good.
Yeah, and I think if anybody has questions, do you prefer the questions to be at the end, or do you want people to ask questions as you speak?
Why don't we have them at the end? Why don't I aim at talking for like another half hour or 40 minutes, and then we'll leave some time for questions.
Yeah, people might have some really interesting questions for you, because I received like 200 odd questions from them.
Okay.
So.
Okay. So let's move from reasons for international arbitration. And again, the slides will have a lot more detail that we just don't have time to go through today. But you should look at in your own time. Why don't we move to the legal framework part of the slide deck? And you can, in particular, as you see on those slides, look at some of the detail about why it is that commercial parties prefer international commercial arbitration. Okay, perfect. Oops, let's go back just a little bit. Okay, so let's take one more step forward. Perfect. So this slide shows us in summary form the legal framework for international commercial arbitration. And as the slide says, this legal framework is quite important to the arbitral process. It's part of the reason that the arbitral process works well. It's part of the reason that commercial parties prefer international arbitration and continue to use it in very significant numbers. This legal framework allows the arbitral process to function reasonably efficiently, and in particular, to fulfill its objective of finally resolving the parties' disputes. And as you can see on the slide, the legal framework consists of some overarching international treaties, international arbitration conventions, and in particular, that convention, the New York Convention, which I've already mentioned a couple times. Those international treaties, conventions, are both elaborated upon and also given effect in individual countries by national arbitration legislation. Almost every country in the world, Nepal included, has its own arbitration legislation, which implements or gives effect to the New York Convention. These national arbitration statutes can sometimes also deal with domestic arbitrations, but in many instances, there's legislation that applies specifically to international commercial arbitration. Sometimes it may also be applicable to some forms of domestic arbitration. Third, international arbitration rules and closely related international arbitration agreements. Most international commercial arbitrations, not all, but most, are conducted as institutional arbitrations pursuant to a set of institutional arbitration rules. And I'll describe what these arbitral institutions are and what the importance of their rules are. Critically important to this entire legal framework, though, is what goes along with the institutional arbitration rules, namely arbitration agreements. As we saw in discussing the definition of international commercial arbitration, you can't have an arbitration unless it's consensual. You need an arbitration agreement. It's the foundation, it's the cornerstone for the arbitral process. If the parties have not agreed to arbitrate, if they haven't agreed to submit their disputes for final resolution by arbitration, then you won't have an arbitration and you won't have an arbitral award that can be enforced. And very frequently, these arbitration agreements incorporate institutional arbitration rules, thus giving them contractual effect. And the final, just by way of introduction, the final layer in this legal framework is so-called soft law. We'll spend some time discussing that. It is guidelines established by either arbitral institutions on the one hand, or alternatively, parts of the international arbitration community aimed at facilitating the arbitral process. Examples are the International Bar Association's rules on the taking of evidence in international commercial arbitration, which sets out some recommended procedures which are not mandatorily applicable in the way that arbitration conventions or national arbitration legislation is mandatorily applicable, but which is often looked to both by arbitral tribunals, but also parties in deciding how to conduct the arbitral process. It's so-called soft law. It's not mandatory, but it guides, it informs how it is that parties and arbitral tribunals use their discretion to conduct the arbitral process. So with that overview, let's jump into the legal framework and look at the next slide. There are a number of international arbitration conventions. You can see them listed on the slide. The most important by far, especially for our purposes, is the so-called New York Convention, but there are also several other conventions which are quite similar and which you may come across in practice occasionally. There's the so-called Panama Convention, the Inter-American Convention on International Commercial Arbitration, which is a sort of American thing, American in the sense of South American, Latin American, and North America, but which basically parallels the New York Convention. There's the European Convention on International Commercial Arbitration, which isn't used that frequently these days and which probably doesn't have a whole lot of direct relevance to Asia. It also largely parallels the New York Convention with a little bit more detail on some procedural aspects. And the final convention that I want to mention before we move on to what's really important, the New York Convention, is the ICSID Convention, sometimes also called the Washington Convention. ICSID stands for the International Center for the Settlement of Investment Disputes. And as the name suggests, that convention is focused very much on investment arbitration, and indeed investment arbitration conducted in front of a specialized tribunal, ICSID, the International Center for the Settlement of Investment Disputes. It has no application to the subject matter of our course, International Commercial Arbitration, and we can therefore leave it for this course's purposes to one side. Let's then move to the next slide, and just by way of overview, look very quickly at examples of national arbitration legislation. By far, the most important is the UNCITRAL model law, the model law on international commercial arbitration. And we're going to spend a good deal of time talking about the model law, both because it's important in its own right, but also because many countries around the world have adopted it either entirely or in significant part. It's also a very good way just to study the arbitral process because it's very thoughtfully organized. Every country, Nepal included, has its own national arbitration legislation. You can see a selection of those statutes on the current slide. In civil law jurisdictions, France, Germany, for example, arbitration statutes are often found in the Code on Civil Procedure. That's the case in France. In common law jurisdictions, United States, England, you often have standalone arbitration acts. In the UK, the English Arbitration Act 1996. In other countries, in Asia, there's the Chinese Arbitration Law, the Indian Arbitration Act, also of 1996. All these statutes are very similar, although there in some circumstances can be important differences, and they all bear many resemblances to the very first item on the list, the UNCITRAL model law on international commercial arbitration. With that, let's move to the next slide. And this picks up on the third category, the institutional arbitration rules, which get incorporated by the parties' arbitration agreements. Almost every country, a little bit like national airlines, has its own arbitral, indeed its own international arbitral institution. You can see some examples on the current slide. There are, as a consequence, hundreds of international arbitration institutions around the world. There are perhaps too many international arbitration institutions, but the leading ones are on the current slide. Based in Paris, the so-called ICC, the International Chamber of Commerce, International Court of Arbitration, is the largest, the best known, and probably the most prestigious international commercial arbitration institution in business today. It is not state-owned, it's not state-affiliated, it is a private business institution, and its purpose is to resolve business disputes, international cross-border business disputes. It has promulgated a set of rules, and we're going to look at those rules at various points in the next weeks. There are a number, in addition to the ICC, there are a number of other important arbitral institutions. SIAC, the Singapore International Arbitration Center, is probably the closest one to Nepal. China, the so-called CTEC, the China International Economic and Trade Arbitration Commission, isn't perhaps as well known or popular. The Hong Kong International Arbitration Center used to be more popular. I think it's less popular these days. We can discuss the reasons for that in due course. In Europe, the London Court of International Arbitration, the Stockholm Chamber of Commerce, the Vienna International Arbitration Center are all quite well-known international arbitration institutions. And what all these institutions have in common with, for example, the ICC, is a set of institutional arbitration rules that prescribe, if the parties incorporate those rules into their contract, how their arbitration will be conducted. And very importantly, all these institutions also perform certain services for parties who arbitrate under their rules. Most importantly, those services include selecting arbitrators if the parties can't agree, dealing with the financial aspects of the arbitration, making sure that the arbitrator's expenses and fees are paid. In some circumstances, making some procedural decisions. For example, should a case be fast-tracked or not? Should two cases be consolidated or not? And the scope of the arbitral institution's involvement in the arbitration will depend upon their particular institutional arbitration rules. Next slide, please. The sort of related to the previous slide, arbitration agreements, which is what it is that incorporates institutional arbitration rules, are extremely important in this legal framework. You never get into the New York Convention or national arbitration legislation. You never have an arbitration unless you have an arbitration agreement. We saw previously arbitration is consensual, it's contractual. Unless you have an agreement to arbitrate, you don't have an arbitration. You can't use the New York Convention or the UNCITRAL model law. There are, and we're going to come back to this subsequently, but there are several different types of arbitration agreements that it's worth keeping in mind, even just by way of introduction today. First, there are so-called submission agreements. The submission agreement is when the parties already have a dispute, which isn't subject to an arbitration agreement. Two people perhaps have an oral or verbal contract without any thought of arbitration. They agree to sell, I don't know, a car from one person to the other person. And a dispute arises about either the payment of the purchase price or the quality of the car, whether it's defective or not. And they agree, rather than going to a national court, to submit that dispute for final resolution to arbitration. Where you submit an existing, not a future, but an existing dispute to arbitration, that is called a submission agreement. And you have an arbitration agreement, which is an entire contract. And the only thing the contract does is submit that dispute to arbitration. To take a real world example, my first arbitration case, actually, the so-called Rainbow Warrior affair. In the 1980s, the French Secret Service agents did things they shouldn't have done. They bombed an environmental protest ship, the so-called Rainbow Warrior, when it was moored in Auckland Harbor in New Zealand, in order to stop it from protesting French nuclear testing in the South Pacific. Obviously, no arbitration agreement between Greenpeace and France prior to the bombing, no contact of any meaningful sort between those parties. After the dispute arose, though, after it was discovered that the French agents had blown up the Rainbow Warrior, the parties, Greenpeace on the one hand, Republic of France on the other, agreed to submit their dispute about that bombing to arbitration. Highly unusual, but a very good example of a submission agreement. The parties have an existing dispute, who's responsible for and what are the financial consequences of the bombing of the Rainbow Warrior, to arbitration to get a final resolution. Why did the parties agree to do that? They agreed to do it for many of the same reasons that businesses choose to submit their commercial disputes to arbitration. The parties wanted a even-handed, they didn't want to go to France, they didn't want to go to wherever Greenpeace might be based, they didn't want to go to New Zealand. They wanted an even-handed means of efficiently and expeditiously resolving the dispute by an expert tribunal. And they wanted a decision that would be final and binding and enforceable. And so they submitted an existing dispute to arbitration for final resolution. And the tribunal finally resolved the dispute, awarded a significant monetary payment from France to Greenpeace, which was duly paid. And the dispute was, notwithstanding its unusual character and a highly unfortunate character, was effectively resolved by arbitration. Submission agreements are relatively unusual. Once a dispute arises, parties often aren't in a very cooperative mode, notwithstanding what happened in Greenpeace versus France, and you don't get huge numbers of submission agreements. Much more common is the second item on our list, arbitration clauses in commercial contracts. Most arbitrations arise from so-called arbitration clauses in a commercial contract. Importantly, these clauses differ from so-called submission agreements in important ways. As we saw, a submission agreement refers to an existing dispute. Arbitration clauses in commercial contracts refer to future disputes, disputes which don't already exist when the arbitration clause is agreed to. Parties enter into a written contract for sale of that car that we referred to a few moments ago. Neither side thinks that there's already a dispute. Both sides hope very much there'll never be disputes, but they put an arbitration clause in their contract that says something like the following: all disputes arising out of this contract shall be finally resolved by arbitration. And then, lo and behold, 2 months, 2 weeks, 2 days later, a dispute arises. The buyer doesn't pay. The buyer concludes the seller's car really isn't a very good car, doesn't want to pay, something of that sort. The arbitration clause in the party's contract covers that future dispute. It's a dispute that arises out of the party's contract, even though it didn't exist at the time that the parties concluded either that contract or their arbitration clause, their arbitration agreement within that contract. Importantly, there's another difference also between arbitration clauses in commercial contracts and submission agreements, and that's the nature of the agreement. The submission agreement, as I mentioned, is an arbitration agreement and nothing else. There's no commercial contract attached to it. The parties simply agree to submit a dispute to arbitration, and their arbitration agreement, the submission agreement, sets out what the dispute is. It's a dispute about the delivery of a car under a particular contract, or it's a dispute about the blowing up of the Rainbow Warrior in Auckland Harbor. And it provides for a particular means of arbitration. 1 arbitrator, 3 arbitrators, arbitral seat in country A or country B, perhaps a choice of law provision, perhaps something about how long the arbitration will take, or something of that nature. But the only thing in the submission agreement is an arbitration agreement with the details about the arbitration. In contrast, the arbitration clause in a commercial contract is one provision in a much broader commercial contract. Even the simple contract to buy and sell a car that we referred to before would have probably 20 provisions about the time of delivery, about warranties as to the condition of the car, about the payment of the purchase price, about a right to reject, and the like. Most of those provisions will have to do with the commercial substance of the party's contract. One clause, though, in the contract will be an arbitration clause. It will provide, like I said before, that all disputes arising out of or relating to this contract, the car sales contract, shall be finally resolved by arbitration. That arbitration clause is itself considered a separable or autonomous agreement. We're going to come back to that concept, the notion of separability or autonomy of the arbitration clause in due course, but it's a very important concept. It defines how the arbitration agreement relates to the rest of the party's contract. But most arbitration agreements are, in fact, these kinds of arbitration clauses contained within more general commercial contracts, which cover future, not existing disputes. And the final point on this slide, so-called model arbitration clauses. Many, but perhaps not enough, arbitration clauses in commercial contracts are based on so-called model arbitration clauses. If you think back to that long list of arbitral institutions that I described a few moments ago, the ICC, the Singapore International Arbitration Center, and the like, each one of those institutions, in addition to promulgating a set of institutional arbitration rules, also publishes a model arbitration clause. The clauses are all quite similar. Obviously, they name different institutions, but they're all quite similar. They all say something like the arbitration clause that I've already mentioned to you hypothetically a couple times. They say something like the following: all disputes, controversies, or disagreements arising out of or relating to this contract shall be finally resolved or finally settled by arbitration conducted in accordance with or pursuant to the rules of the, and then you can fill in your favorite arbitral institution, International Chamber of Commerce, or something of the sort. Almost all institutions have published model clauses, a lot like what I've just said, and we will see some examples in a few moments. And commercial parties very frequently use those model arbitration clauses in their commercial contracts. They do so for good reason, because arbitration clauses of that nature have been carefully considered over literally generations of commercial lawyers and arbitration lawyers. All the kinks have been worked out of those clauses, and they don't have mistakes or confusions or inconsistencies in them. When parties agree to those clauses, they get a time-tested and pretty efficient means of dispute resolution. Whereas if you start from scratch and draft your own arbitration clause without regard to what people have done in the past, you can very frequently, especially if you're not an arbitration expert, commit the same types of mistakes that many people have committed in the past, leading to exactly the opposite of what the arbitral process is intended to provide, an efficient and expeditious means of dispute resolution, instead leading to some procedural chaos. We'll see some examples of that during the remainder of this course. But with that introduction, let's move and look at the final layer, just by way of introduction, of the legal framework, and that is so-called soft law or best practices. There are a number of good examples of this kind of soft law. You can see them on the slide. I mentioned previously the IBA rules on the taking of evidence in international commercial arbitration. So these IBA rules, the International Bar Association's rules, aren't really rules in the sense of you ordinarily have to follow them, like rules in a university. They are instead, as the second and third items on the list indicate, in the nature of guidelines. Only if the parties contractually accept these rules or the guidelines will they become mandatory and binding rules. Otherwise, they're just a set of proposals written by an IBA committee, a bunch of lawyers, without any official, formal, or governmental authority. Their rules, the IBA rules on the taking of evidence, are nothing more than nothing different from graffiti on somebody's wall, some suggestions made by a civic-minded group of lawyers about how arbitration might be conducted efficiently. But very importantly, many parties and many arbitral tribunals think that these rules, which describe, for example, how it is that witness statements should be prepared, how they should be constructed, what they should contain, what they shouldn't contain, how cross-examination and hearings should be conducted. These rules on the taking of evidence are quite influential. They're kind of soft law or best practices, which both parties choose to follow and arbitral tribunals look to for guidance. And the same is true with respect to the other three items on the list, the IBA guidelines on conflicts of interest of arbitrators, which defines disclosure duties of arbitrators and also circumstances in which they can be challenged, IBA guidelines on party representation, how it is that parties, lawyers, their counsel, people like you in the future, must conduct themselves in an international arbitration, the UNCITRAL, the United Nations Commission on International Trade Law, notes on organizing arbitral proceedings, which address basically procedures in the entire arbitral process. All of these sources provide guidance, soft law, on how it is that the arbitral process can be more efficiently conducted. And we will come back. The reason I'm identifying all of these in the introduction is that we should come back to these at various points as we explore international arbitration in a little more detail. With that overview, let's jump into, in a little bit more detail on the next slide, what's contained within each one of these headings. And if we could just, yeah, there we go. So, by far the most important international treaty applicable to international commercial arbitration is the New York Convention. The New York Convention isn't really its name. Its real name is the UN, the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards. Because that's such a mouthful, and also, as we will see, because the title's actually not all that accurate, people call this convention, the UN Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention. They call it the New York Convention because it was negotiated and drafted in a fairly short period, a number of weeks, in 1958 in, of all places, New York. And this convention, the New York Convention, brought together two earlier international agreements, the so-called Geneva Protocol on arbitral clauses and the Geneva Convention on arbitral awards. It combined them to deal with both arbitral clauses or arbitration agreements on the one hand, and arbitral awards on the other hand. It was, the New York Convention was the first of the international arbitration, commercial arbitration conventions in existence. And it has become over time what I like to call a global constitution for international commercial arbitration. It's constitutional because it is essentially universal. It's accepted by almost every country in the world, save, say, North Korea. And it is drafted in a constitutional manner. That, by that I mean it's drafted in general rather than detailed terms, which leaves a good deal of room, requires a good deal of room for future development depending upon circumstances. Let's look at the convention in a little more detail. If we could go to the next slide. And we can skip over the materials on the here. This is a good place to stop. We can skip over the materials on the Geneva Protocol, which dealt specifically with international arbitration agreements and made those arbitration agreements valid and enforceable, subject to only very limited exceptions. And it also, as I mentioned previously, superseded and, in a sense, incorporated the Geneva Convention on arbitral awards, which did the same thing for arbitral awards that the protocol did for arbitration agreements, namely made foreign arbitral awards valid and enforceable, subject to only very limited exception. And as I mentioned previously, the New York Convention is by far the most significant contemporary, currently applicable instrument relating to international commercial arbitration. If we go to the next slide, please. And we can skip over this. And we can, oops, back one, please. Back two, please. There we go. So I mentioned previously that the New York Convention was drafted in New York, 1958, 3-week long international conference, 45 countries involved. At first, and it produced a final draft of the convention. The New York Conference, that's what it was called, was successful. Often you have these kinds of conferences and they don't produce anything, but the delegates here managed to reach agreement. But at first it looked like the convention was going to be a bit of a failure. Only 26 of the 45 countries that took part in the conference actually signed the convention. The first 3 countries to execute the convention were Israel, Jordan, and Egypt. Somewhat unlikely bedfellows in some sense. And also importantly, most other countries didn't ratify the convention either right away or for some time. It took a long time before countries began to actually think the convention was a good idea. The United States, for example, didn't ratify until 1970, more than a decade after the convention was opened for signature. But slowly, a big jump in the 1990s, the convention effectively became universal. As you can see on the slide, 2016, February, there were 156 contracting states, and I think the current number is 173 or thereabouts. It's essentially universal, essentially global. There are a couple exceptions. I mentioned North Korea. Very unfortunately, Taiwan is not a party to the convention because of intransigence on the part of the People's Republic of China, which won't permit it to ratify the convention. That's very unfortunate given the importance of the Taiwanese economy in world affairs. But apart from countries like that, the convention is essentially global. All European Union member states, all states in North and South America, virtually all states in Asia and in Africa have ratified the convention, and it is essentially global. It is, as I said previously, a global constitution for international commercial arbitration. So what is this thing, this convention I've been going on about? What does it say? Let's look in the next slide. First, it's set forth in 5 authentic languages: English, French, Spanish, Russian, Arabic, and Chinese. I guess that's 6. And it's only a few pages long. The real bits of the convention are 1.5 pages long. And the important parts of the convention, it's 1.5 dozen articles long, are in the first 7 provisions, articles 1 through 7. And those articles are focused not on a detailed discussion of the arbitration process, but quite specifically on 2 main topics. 1, recognition and enforcement of arbitration agreements, and 2, recognition and enforcement of arbitral awards. And in that sense, the convention brings together those 2 earlier instruments that I alluded to briefly, namely the Geneva Protocol on Arbitral Clauses and the Geneva Convention on Arbitral Awards. If we could look at the next slide. The convention provides uniform international rules for both those 2 topics: the recognition of foreign arbitral awards and the recognition of international arbitration agreements. Awards are dealt with in Articles 3, 4, and 5. And as I mentioned, the convention's object is, sorry, my cat wants to participate. The convention's object is to establish uniform rules that facilitate the recognition and enforcement of foreign arbitral awards. In Article 3 begins that by stating the basic rule that every contracting state, each state that ratifies the convention, shall recognize arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon, under the conditions laid down in the following articles. So essentially, subject to of course, the judicial procedures, the rules of civil procedure for how you file cases in each contracting state. Every contracting party, all 173 contracting states to the New York Convention, promises that they shall recognize arbitral awards as binding and shall enforce them. And then if we move to the next slide, we can see what the conditions laid down in the following articles are. Article 4 of the convention then sets out rules for the proof of arbitral awards. And it provides, you can see this in Article 4.1, to obtain the recognition and enforcement mentioned in the preceding article, that's Article 3 that we just looked at, the party applying for recognition shall. And then Article 4 goes on to provide that the party seeking recognition, sometimes called the award creditor, the party seeking recognition of an award shall provide 2 things. 1, a copy of the award with a translation if necessary, and 2, a copy of the arbitration agreement, again, if necessary, with a translation. That's all you need to do to prove that you have an arbitral award. Provide a copy of it, original or a certified copy, and translation, and do the same thing with the arbitration agreement that gave rise to the award. That requirement, incidentally, for producing the arbitration agreement underscores the consensual nature of arbitration. Again, fundamental to having an arbitration, to being able to enforce an arbitral award, is that the arbitration was consensual, that it arose from an arbitration agreement, contract. And if you don't have that, then you don't even have an award that you can recognize and enforce. Importantly, then, if we can just go back 1. Yeah, perfect. Nope, forward 1 again. There we go. And then Article 5 of the convention, because you remember I told you that the sections of the convention dealing with awards are in 3, 4, and 5. Article 5 then provides in subparagraph 1, recognition and enforcement of the award may be refused at the request of the party against whom it is invoked, only if that party furnishes to the competent authority where the recognition and enforcement is thought proof that. And then there's a list in Article 5 of 5 plus 2 exceptions to the presumptive validity and enforceability of arbitral awards. Those are very narrow exceptions. There's an exclusive list, only 7. So basically what these 3 provisions, Articles 3, 4, and 5 do is impose an obligation to recognize foreign awards, establish a mechanism to prove the existence of those awards, Article 4, which is very fast and expeditious. And number 5 provides that the award will be denied, may be denied recognition only in very limited circumstances. A closed list in Article 5 of circumstances where, for example, the tribunal exceeded its jurisdiction or committed a very serious procedural error or violated the public policy of the recognition state. Apart from that, there's no basis for denying recognition of an award. There's no exception to Article 3's mandatory requirement to recognize awards. Importantly, there's no review of the merits or substance of the arbitrator's decision in their arbitral award. There's no appeal in which you can say the arbitral tribunal misunderstood the evidence or misinterpreted the party's contract. Next slide, please. And we can skip this one. And so Articles 3, 4, and 5 deal with the presumptive validity and enforceability of arbitral awards. Article 2 does the same thing for arbitration agreements. And you can see the relevant text on the slide. Each contracting state shall recognize an agreement in writing under which the parties undertake to submit to arbitration all or any differences which have arisen or which may arise between them. That obligation, each contracting state shall recognize, is the same for agreements as it is in Article 3 for arbitral awards. A mandatory international law obligation to recognize arbitration agreements, just like there's a mandatory international obligation to recognize arbitral awards, subject to only very limited exceptions, those that we saw in Article 5. Now, it's worth, while we have Article 2.1 here on the slide in front of us, just to remind ourselves of a couple things that we've talked about already today. One, note how arbitration is really based upon consent. It's consensual. In Article 2, as well as Article 4, which I mentioned a few moments ago, underscores that the need to have an agreement in writing under which the parties undertake to submit to arbitration certain differences. Arbitration is fundamentally consensual. No arbitration agreement, no arbitration award that can be recognized. And second, note that arbitration in this text here, it sort of explicates the nature of arbitration, is about resolving differences. The parties undertake to submit to arbitration all or any differences. Arbitration is not about making a new contract or creating a new relationship. It's about resolving differences, disagreements, disputes, which have already arisen, or which may arise in the future. And that takes us back, if you'll remember, to the difference between submission agreements and arbitration clauses covering future disputes. And you can see that same distinction picked up here in the text of Article 2.1. An agreement to submit to arbitration all or any differences which have arisen, that's a submission agreement, or which may arise, and it doesn't say it, but it means it, in the future between them. An agreement to resolve future disputes by arbitration. Next slide, please. And then finally, national courts are not just required to recognize arbitration agreements as valid, but they're also required to do a particular thing if there's an arbitration agreement. And that particular thing is described in Article 2.3. You can see Article 2.3 on the slide. It says, the court of a contracting state, when seized of an action in a matter in respect of which the parties have made an agreement within the meaning of this article, shall, at the request of one of the parties, refer the parties to arbitration, unless it finds that the said agreement is null and void, inoperative, or incapable of being performed. That's a mouthful, but let's try and take it apart piece by piece. Most importantly, Article 2.3 creates a specific remedy if a party violates an arbitration agreement. What do I mean? Two parties agreed in that car sales contract I mentioned at the beginning of class to arbitrate future disputes about the quality of the car. A dispute arises. One party decides they don't much want to arbitrate. They'd rather sue in national court. So they file a suit about their car quality dispute in a national court. What Article 2.3 says is, assuming the arbitration agreement is valid, the remedy for that is to refer the parties to arbitration. And you can see that the clause begins, the court of a contracting state, when seized of an action in a matter in respect of which the parties have made an arbitration agreement, shall, mandatory, at the request of one of the parties, refer the parties to arbitration. What that means is the court can't say, yes, there's a valid arbitration agreement, but I'm not going to refer the parties to arbitration. I'm just going to award damages because of the breach of the arbitration agreement, like you can award damages for breaches of other types of contractual provisions. Instead, the New York Convention says, if there's a valid arbitration agreement, the remedy is to refer the parties to arbitration. They can't litigate that dispute in national courts and then fight about whether or not there were financial consequences from breaching the arbitration agreement. They have to go to arbitration to resolve their dispute. And as a consequence, the litigation will either be dismissed or stayed in favor of the arbitration. Note that arbitration is, in a sense, a private right, and a party has to ask for its right to arbitrate to be respected. We can see that in Article 2.3, where the court of a contracting state, when seized of an action which is subject to arbitration, shall, and then at the important bit, at the request of one of the parties, refer the parties to arbitration. Parties can waive their right to arbitrate. They can decide if one party wants to litigate, the other party can say, actually, I'd rather litigate too at this point. Doesn't happen very frequently, but arbitration is a right that a party must exercise. And if it doesn't, it will be held to have waived that right. We will see a number of instances during this course in which rights to arbitrate or rights under an arbitration agreement can be waived and therefore lost. Finally, some exceptions, limited exceptions, but nonetheless exceptions to the validity, presumptive validity of the arbitration agreement. Court must refer the parties to arbitration unless it finds that the said agreement is null and void, inoperative, or incapable of being performed. Unless you fit within one of those things, null and void, inoperative, or incapable of being performed, the arbitration agreement is valid, subject to a mandatory obligation of recognition. Why don't we try to do one more set of slides, and then we can do some questions. Finally, there is Article 7 of the New York Convention, which is important, and it's a little bit complicated, especially on the first day of class. Oops, let's go back, please. It's a little bit complicated on the first day of class, but it's a very important structural feature of the arbitration obligations under the New York Convention. We'll first look at what Article 7, subparagraph 1 says, and then I'll try to describe what I mean by a structural or architectural feature. Article 7.1 provides a convention, the New York Convention, shall not deprive any interested party of any right she may have to avail herself of an arbitral award in the manner and to the extent allowed by the laws or treaties of the country where such award is sought to be relied upon. So what does that mean? What that means is the New York Convention, as we've seen, establishes obligations on contracting states to recognize arbitral awards, subject to some exceptions. The convention mandatorily requires, unless one of those exceptions is shown to be applicable, that the award be recognized. The country fails to recognize the award, it breaches its treaty, it breaches international law. What happens, though, if one of the exceptions permits a country to deny recognition of an award, and the country doesn't want to? The country could, consistent with the convention, deny recognition, for example, because the award had been set aside or annulled in another place, in the arbitral seat. But the country says, we don't care that it was annulled. We want to recognize the award anyway. Under our law, in this jurisdiction, the award is valid and binding, notwithstanding the fact that it was annulled somewhere else, and notwithstanding the fact that we would be within our rights, we wouldn't violate the convention if we denied recognition. Can the country recognize the award? Answer, yes. The answer is yes, because nothing in the convention, according to Article 7.1, deprives any party of a right to avail herself of an arbitral award in the manner and to the extent allowed by the laws of the country where the award is sought to be relied upon. What Article 7.1 does is creates a minimum floor that countries must respect in recognizing arbitral awards and arbitration agreements. They can't deny recognition of an award or agreement in circumstances where the convention requires recognition. But, and this is the important part, the convention doesn't set a ceiling. The convention doesn't ever require non-recognition of either an agreement or an award. It only requires recognition. It never requires non-recognition. And that's because the basic purpose of the convention is to facilitate, to promote the recognition and enforcement of international arbitration agreements and awards, not to restrict it. And if a country wants to recognize more agreements and more awards than the convention requires, the convention, and Article 7 says this, the convention doesn't prohibit that. In fact, the convention specifically preserves national law in that respect. One final point, and then we're going to do questions. I told you that the official title of the New York Convention is inaccurate. Let's think back to what that title was and why I might have said that. The official title of the New York Convention is the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards. Why is that inaccurate? It's inaccurate because the convention actually deals very importantly with a different subject matter as well. That different subject matter is in Article 2. It is the recognition and enforcement of international arbitration agreements. Why is the title of the convention limited to awards? Well, the convention was drafted fairly quickly, in 3 weeks in New York. People had lots of other distractions, no doubt. And Article 2 was introduced just at the last moment. Maybe not exactly the last moment, maybe in the last few days. And they never got round to changing the title. Before Article 2 was introduced, the title was correct. The only thing the convention dealt with was arbitral awards. But the delegates to the conference realized that it made a lot more sense, as they ultimately did, to deal with both arbitration agreements and arbitral awards in the convention. So they added Article 2, which, as we saw, deals with nothing but arbitration agreements. They didn't get around to fixing the title, and perhaps that's why parties call it, everybody calls it, the New York Convention instead of the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards. And so, although we didn't cover the entire legal framework, we made a lot of good progress towards it. The only thing that is left is the model law and some institutional arbitration rules. And now we have a bunch of questions. How shall we do the questions? Anybody?
Hello, can you hear me?
Now I do.
Okay, perfect. So I received some 200 questions over email.
200.
But
I'm not
yeah.
sure we've got time for 200. This can be like really fast questions, I suppose.
No, actually, I mean, me being the host, I am actually really interested in asking a question.
Fire away.
Thank you so much for doing this lecture. I feel like doing an LLM all the way back again and attending all the classes. So because like most of our audiences today are Nepalese, I get a lot of these questions from students in like the final year of their law school, because the arbitration landscape in Nepal is kind of like very much underdeveloped, and even like parties commercially or even the government, like having signed only 6 BITs so far, out of which 2 are actually just signed and they haven't actually come into force. Like, is arbitration like a topic for Nepal? Can students do that as a matter of career? Yes, like you could do domestic arbitration, but when it comes to international arbitration, could you do that as a matter of career, or do you do just as a matter of hobby? And then the next part of the question is, how do you probably change the legal landscape of Nepal to make it very arbitration friendly so that you get more arbitration cases? What would you do to like, change the legal landscape?
So those are both great questions. I do think that there is scope for Nepalese lawyers, both in Nepal, but also if they're outside Nepal. Arya is a good example, to pursue international arbitration as part of a career path. I always hesitate, wherever students are from, to recommend putting all your eggs in one basket and focusing exclusively on anything, whether it's, I don't know, project finance or M&A or international arbitration. I think one never really knows whether one likes something until you try it. And if you build a whole career on international arbitration, and then when you actually start doing it, you realize this isn't my thing, it's a bit of a shame. So I think to some extent, starting out as a generalist often makes sense, or at least not focusing exclusively on one topic, including international arbitration. But I do think Nepal has sufficient international relations with neighboring countries and otherwise that there will be, and the examples are that you gave at the outset, I think, to validate that or at least illustrate it, will create opportunities for people both in government but also private practice and businesses to do arbitration. To the extent that I'm wrong about how big that practice area might be, I think it underscores my general advice that I give to people from every country, that you ought to try to be a well-rounded lawyer. You ought to focus on things in addition to whatever it is your heart tells you you're absolutely going to love. because it may turn out when you start doing it that you don't actually love it quite so much. In terms of Nepalese reform, I'm probably the least competent person on this call to answer that question. I'm not a Nepalese lawyer. I've never been, apart from this video session, to a Nepalese law school, if this is a Nepalese law school. So you all know better than I do. I do think, though, that every country's arbitration legislation can benefit from both review and reflection, particularly reflection in light of what other jurisdictions have done. The UNCITRAL model law, to the extent that it hasn't been adopted or fully adopted in Nepal, or to the extent there have been past sort of decisions to deviate from it, is, in my view, a very good model. In fact, I've never sort of been associated with UNCITRAL. I don't have any axe to grind for UNCITRAL. If I'd participated in the process of drafting the law, I probably wouldn't be so enthusiastic about it because they probably would have rejected some of my suggestions and my feelings would have been hurt. But looking neutrally and objectively at the model law from the outside, it has a lot of very, very good features. And it also has the unique benefit of being adopted by a lot of other countries. And therefore, when a country adopts the model law and doesn't tinker much with its provisions, one gets also the benefit of well-developed commentary and decisions in other jurisdictions that have thought about these issues. And at least in my view, it's always good to have the benefit of other people's thoughts. It makes one's own decisions better. It creates more predictability for parties and so forth. There's also been recent sort of legislative developments, suggestions for ways to improve the model law. And notwithstanding what I said about the desirability of uniformity, I do think it's worth taking a look at recent legislation to see if there's anything that might specifically benefit Nepal.
Okay, perfect. Adding to that, I just want to share that Gary and I are advising the Nepalese government in reforming our Arbitration Act through ADB. So if any of you in the call are interested and maybe have suggestions as to how we could change the Nepalese Arbitration Act, please feel free to send me an email, or probably we could have another call and we can discuss how we could change the Nepalese Arbitration Act. So that's one. I have a bunch of questions. Maybe this one's a really interesting question, and probably I've heard the answer to this 100 times now, being in so many calls with Gary. What made you want to pursue arbitration, international arbitration? I mean, I've heard this answer 10 times, but
the answer is probably different
benefit.
every time. So it was pretty much desperation. I couldn't figure out what else to do. So I did arbitration. I also always was interested in international matters, and when I guess in a sense things that worked. I often saw national court proceedings in lots of different countries. I wouldn't want to sort of just pick on one country for having, insanely long delays in its resolution of disputes, or pick on some other country for having courts that aren't very independent at all, or pick on some other country as having a reputation for corruption. I wouldn't want to do that. Arbitration, although it's certainly not perfect, at least in my experience, almost always works and almost always gets to a result that, even if it's not something that was my favorite choice, at least is ultimately a fair and satisfactory result. And so because I was desperate for stuff to do, and because arbitration worked, I chose it.
I have like a few more questions, but why don't someone from the audience probably unmute themselves and ask maybe 2 or 3 questions, and then I will take some of the questions from the emails I got. I think we have a hand up. I can't see who this person is, but Hussein, I don't, sorry, I can't pronounce your last name, but yeah, just ask your question.
Hello, everyone. Thank you for this course. Professor, I was wondering whether you can explain how does the New York Convention deals with the asymmetrical arbitration clauses, and arbitration clause which allows to both parties to go either to court or to the arbitration. Thank you.
So we're really diving into the details of arbitration agreements, and to one particular and somewhat exotic type of arbitration agreement. This is, as the question correctly identifies, referred to as asymmetrical arbitration clauses. But my understanding, at least, is perhaps a little differently than the question hypothesized. So an asymmetrical arbitration clause gives one party's rights that the other party doesn't have. That's why it's asymmetrical. It's not symmetrical. A classic symmetrical arbitration clause is the one that I described previously. It provides, if you remember, all disputes arising out of this contract shall be finally resolved by arbitration. Another way to say that would make its symmetry more obvious would be each party to this contract shall have the right to arbitrate all disputes arising out of this contract, or each party to this contract shall have the right and the obligation to arbitrate all disputes arising out of this contract. The reason that the arbitration clause is symmetrical is that it imposes the same obligations and the same rights on both parties. Both parties have a right to arbitrate. Both parties have an obligation to arbitrate. Each party can, as I mentioned previously, waive that right, not invoke it, but in principle, the arbitration clause is symmetrical. An asymmetrical arbitration clause is different. An asymmetrical arbitration clause says Professor Bourne and Professor Dixit agree to arbitrate all disputes arising out of their car purchase agreement. Provided, however, Professor Dixit can, in the event she wishes to, go to Nepalese courts. That's an asymmetrical clause because it gives her rights I don't have. It's asymmetrical. She gets rights that I don't have. And some national courts have said asymmetrical clauses are invalid, particularly as a matter of domestic arbitration law. And the notion, perhaps not unsurprisingly, is either that they're unconscionable, that they give one party disproportionate rights that are too important to allow them to be disproportionate, or that the contract doesn't have mutuality, like it needs to be, in a sense, symmetrical. Most courts have rejected, outside of some limited context, these arguments. Most courts have said, if Professor Bourne and Professor Dixit want to agree to resolve their disputes that way, Professor Bourne's a big boy, and he has to live with the consequences of Ms. Dixit having a choice, whether to go to arbitration or otherwise. And for all we know, Professor Bourne got some advantages in the arbitration clause, or maybe otherwise, that sort of counterbalance this asymmetry. There's a recent, maybe not so recent, like 5-year-old European Court of Justice case that involves a form selection clause where there was an asymmetry of that of that character, and it was held null and void. In general, these kinds of asymmetrical clauses probably would be upheld in many jurisdictions, at least if the parties had more or less equal bargaining power, but they give rise to pretty significant procedural complexities. You're almost certainly going to have a fight about whether they're valid. So Professor Dixit shouldn't try to impose that clause on me.
Thank you. I'm just going to read a few questions from the chat. Unless Tukulov Kasilgov, do you want to ask a question? I think you're still on mute. Okay.
Oh, now you can hear me, and
Yep.
thank you for conducting this lecture and for the whole this alumni network of Nepal for letting your Kazakh peers to join too. And Professor Born, my question will be, can you please give us some general advice as to how to conduct the research in arbitration? What should we always keep in mind when we do this work? What is so specific in arbitration that we have to always consider? I hope my question was clear enough.
Yes, by all means. So, I mean, it's a hard question in a way because it depends a little bit on the particular issues and types of questions that you would want to be researching. Assuming that it is a question of international arbitration law, then I think there are sort of two main categories of things that you would probably want to look at. One would be international authorities that would address what the New York Convention means, that would address how courts in a number of different countries have looked at particular issues. So if you wanted to sort of research the question of what law governs an international arbitration agreement, you'd probably want to look at a fair number of these authorities. Or if you wanted to look at what the standards for independence and impartiality of an arbitrator in a foreign seated arbitration are, you'd almost certainly want to look at these international authorities. There are a variety of ways that you can do it. Just plain old Google is a pretty good starting point. Kluwer Arbitration has an amazing library. It's behind a paywall, or at least many bits of it are behind a paywall, but finding a way through your law firm, through your university, some other way to get access behind the paywall, I think is quite important. Many libraries have hard copies of leading international texts. So I said there are two categories though, and the other category would be, depending on your jurisdiction, there may be local law, domestic law that bears on the question. Just by way of example, here in England, the English Arbitration Act addresses a number of issues. English courts would certainly pay attention to the first category that I described. They cite foreign authorities, international authorities, but they look very much to their own domestic authorities also, interpreting their own domestic legislation, the English Arbitration Act. And so you would want to pay a lot of attention, if it was a question under that law, under the English Arbitration Act, to that local legislation. And the same thing obviously would be true, you know, for Nepal, for other jurisdictions. I suppose there's a final general category, which is sort of how do you do an arbitration? And sort of put aside a question of, you know, what law governs an arbitration agreement, or when does an arbitral award need to be recognized or not, and ask instead the question of, you know, can you cross-examine somebody on issues that aren't addressed in her witness statement, or which party gets to have the last word in closing submissions? A question about arbitral procedure, in a sense. How is it that you conduct an arbitration? And there you absolutely want to look to that first category, the international authorities, and also to some of that soft law that we saw on a slide half an hour or so ago before. And
Maybe
the
I'll
really
just
important thing is you should always assign a very good associate or younger lawyer to research these things for you, because no doubt they'll find stuff that you don't find.
Yeah, associates always come in handy. I think I'll just have like two more questions, unless you have like some really interesting, fun questions. I think this is an interesting one and also kind of related to Nepal. So someone called Asta Powder. She says, recently the Supreme Court of Nepal declined to enforce an arbitral award rendered in India. The reason of the court was India does not list Nepal in a reciprocating territory list, and the New York Convention accepts principle of reciprocity even amongst contracting states. Given that both countries are party to the New York Convention, is there reciprocity reservation provision even among contracting parties?
Yes, so that's interesting. I didn't know about that Nepalese decision. I would love it if somebody would send it to me. I'll put it in the next edition of my treatise. So India does have, perhaps a little unusually, a list of countries to which it accords reciprocity. It's not a great idea, to be honest, on the part of India, because it creates exactly this kind of issue. But unusually it does. Most countries don't have that. So the United States, for example, there's no list of reciprocating countries. The United States would accord New York Convention status to an award from any contracting state to the New York Convention. You don't need to be on a list. There is no list. But India's got that list. And if you're not on the list, it certainly creates the possibility for a pretty serious argument that India wouldn't, in fact, recognize your awards. That's proposition one. Proposition two, the New York Convention has in it a reciprocity reservation mechanism. I don't know whether or not Nepal has made a reciprocity reservation, but it can. It can, under Article 1, provide that it will only recognize awards from countries which are party to the convention. And at least arguably, the Indian lack of putting Nepal on its reciprocity list would, if Nepal made the reciprocity reservation, justify Nepal in denying recognition of Indian awards. If Nepal has not made a reciprocity reservation, it can't unilaterally use reciprocity to deny an award. So proposition 2 is, did Nepal make a reciprocity reservation? If yes, then a reasonable argument that it is right in what the Nepalese Supreme Court was justified in denying recognition of the Indian award. I suppose if I were the Indian award creditor and wanted to complain about the Nepalese judgment, I would try and find Indian authority that says we'd recognize a Nepalese award even though you're not on our silly list. And in the event that India, in fact, recognizes Nepalese awards, or has it, perhaps more accurately, has a general rule that it will recognize the awards of any New York Convention contracting state, then I think the Nepalese decision becomes a little bit harder to justify.
So where would you go to like actually challenge the Nepalese Supreme Court judgment? Like, let's say the Indian creditor who's been denied enforcement in the Nepalese courts, where would they actually go? Because like this is like the Nepalese Supreme Court denying recognition and enforcement.
Yeah, I suppose you could, although this would be very difficult, if there's a bilateral investment treaty, arbitral awards have in some circumstances been treated as investments, and a wrongful Nepalese denial of recognition arguably could give rise to a bilateral investment treaty claim. I think it's unlikely and it would depend on what the award relates to. I think the award would need to relate to an underlying investment in Nepal, as opposed to, for example, some kind of trading contract that doesn't have much or anything to do with Nepal. But I mean, apart from that, you obviously can't further appeal a Nepalese Supreme Court decision. You can take your Indian award somewhere else to go after other assets of the Nepalese award debtor if it has assets in, Singapore and New York, in some other jurisdiction. You could try to recognize there.
I see Anjali Sharma has her hand up. Do you have a follow-up question, or do you have a new question?
I actually have a new question, if I may.
Okay, yeah, perfect. Go ahead.
Yeah. So my question is,
Do you want to turn on your video? Maybe?
I'm actually not
That's
in
okay.
the
That's okay. Don't worry.
So now my question is there a way to determine when exactly the arbitration can be invoked, or like what exactly do we, refer to as disputes? Because a bit of context to the question that I'm trying to ask is that, like, in my practice as a public prosecutor, we have seen a lot of cases where a private party where a contract there's a contract between a private party and a government institution, and then in contract the government institution also submits to arbitration. However, in practice, the government institutions are most often hesitant to submit to arbitration. So what happens is, in that case, when a private party tries to invoke arbitration and comes up to the high court for uh, with an application to appoint the arbitration tribunal, the claim that the government institutions take or raise is that there's no dispute in the first place for them to submit to arbitration. And I wonder if that is even a valid claim for government institutions to raise, because what happens in that instance when one party is raising a claim, trying to invoke arbitration because they feel that there's been a dispute, and the other party is raising a claim that there's no dispute at all for them to submit to arbitration. So what happens in that case, and whether if it is up to the party invoking arbitration to determine if there is a disagreement or a dispute at all.
So great question. You'll be glad to know Nepal's not alone with this set of issues. First, a practical observation, and then a little bit of law. The practical observation is that you can avoid a lot of these questions by including an institutional arbitration clause in your arbitration agreement. In those circumstances, you don't have to go to court, and you therefore don't have to fight with a Nepalese judge about whether or not there is a dispute. The arbitral institution will appoint an arbitral tribunal without looking in a meaningful way at whether there's a dispute. If one party files a request for arbitration pursuant to the institution's rules, then the institution will appoint an arbitral tribunal, leave it to the arbitral tribunal to consider whether or not there's a dispute, and if so, who's right and who's wrong. And you avoid the whole potential of a court saying, oh, there's not really a dispute here. So that's practical answer. The answer in terms of law is that there in the past was a substantial body of English authority, and then subsequently other common law authority. New Zealand, for some peculiar reason, seemed to have a lot of this also, which addressed exactly this issue. One party would say, we may be writing lots of nasty letters to each other, claiming this and claiming that, but there's really no dispute here. And often they would say, there's no dispute here because I'm so clearly right, even though the other party said, you're clearly wrong. Or they would say things like, well, the dispute isn't ripe yet. There may be a dispute in the future, but it's not really a dispute right now. And English courts in the past used to say, well, this isn't a very serious dispute, so it's not a dispute. Or one party pretty much admits that it's liable, but won't pay, so there's no real dispute. English courts about 25 years ago, New Zealand courts a little bit more recently have rejected that whole line of things and said, dispute means if one party wants you to do something and you won't do it. So I'm asking for money, you won't pay. Doesn't matter if you say, I obviously don't have to pay. Doesn't matter if you say, yes, I have to pay, but I can't. There's still a dispute in all these cases. If one party wants money or wants an award saying you have to pay and you won't give the money or you won't consent to the award, then there's a dispute. And I think that actually makes a lot more sense, that sort of more contemporary view, which almost all courts adopt, because arguments that there's not really a dispute, virtually always occur in cases when both parties say there's no dispute because I'm so obviously right. And that's a quintessential definition of a dispute.
Thank you. So I think we're like 2 minutes past our allocated time. Unless somebody has like really interesting question. I mean, I am actually now, after 2 hours, I'm like, okay, I don't want to talk law anymore. But if anybody has questions about his book, The File, or if you want to say like a few words about your book and why everybody should read it, that could be interesting.
So I didn't pay Arya to do a commercial about my book, and
He
I'm not
hasn't
gonna-
paid me, and well, I am literally like very, very excited about the book, and because I also know a little bit about his next upcoming book, The Priest. Like I get like really excited about about my ex-boss's novels, so that's why I'm just like, okay, why don't you tell us a little bit about your book?
That's really sweet. So I think you would all love my book. If you like spy thrillers with exciting action heroines, and if you're bored with whether it's public prosecution or international arbitration or whatever else, it provides a nice beachside, lakeside, or mountaintop reading, as the case may be in Nepal. It's been a real pleasure with you all. I hope we can have a chance to do this again at some point. If you're ever in London, stop by and say hello. And thank you again for the privilege of being with you all. Thank you.
Thank you. Thanks all. Bye.
Bye, everyone.